Hey everyone, and welcome back to the channel. Let's talk about something a bit serious today, but super important. What happens if you die without a will? It's a question many of us avoid, maybe thinking, I don't have much, or it'll all just go to my spouse anyway. But the reality is a lot more complicated, and it can create a huge mess for the people you love. When you pass away without a will, it's called dying intestate. In this situation, the government doesn't just swoop in and take all your stuff. That's a common myth. Instead, your state's laws, called intestacy laws, decide who gets what. And here's the catch. Every state is different. What happens in California is not what happens in Texas or New York. So, who usually inherits? The law follows a pretty strict pecking order based on your family tree. Typically, your surviving spouse is first in line. But it's not always as simple as them getting everything. For example, in many states, if you have a spouse and children from a previous relationship, your assets will be split between them. Your spouse might get 1/3 or 1/2, and the rest goes to your children. If you have a spouse and children together, your spouse might get a larger share, or even everything. But again, it depends on the state. Now, what if you're not married? If you have children, they are next in line. Your property will be divided equally among them. If one of your children has passed away but had kids of their own, your grandchildren, that child's share will typically go to them. This is called per stirps distribution, a fancy term for by branch of the family tree. What if you have no spouse and no children? Then the law looks further up your family tree. First, it goes to your parents. If your parents are no longer living, it will go to your siblings. If a sibling has passed away, their share will go to their children, your nieces and nephews. The line of succession can keep going to grandparents, aunts, uncles, and cousins, getting more and more distant until an heir is found. This is where the major pitfalls come in. The biggest one? The law doesn't care about your relationships or what you would have wanted. Your best friend who was like a brother to you? They get nothing. Your stepchild you raised as your own? They're legally not your child, so they get nothing. A long-term, unmarried partner? In most states, they have no inheritance rights under intestacy laws, no matter how many years you spent together. This can be devastating. Another huge problem is unintended heirs. Imagine you have a strained relationship with a sibling and haven't spoken in 20 years. If they are your closest living relative according to the law, they could inherit everything you own. Or consider a blended family. You might have wanted your stepchildren to inherit alongside your biological children, but the law won't see it that way. And let's not forget the process itself. Without a will, a court has to appoint someone to manage your estate. This can lead to family disputes over who should be in charge. It also makes the process, known as probate, much longer, more expensive, and more public. Everything becomes part of the public record. The bottom line is that intestacy laws are a one-size-fits-all solution that rarely fits anyone perfectly. They are a safety net, but a very impersonal one. The only way to ensure your wishes are followed, to protect your loved ones, and to avoid unnecessary conflict and expense is to have a legally valid will. It doesn't have to be complicated. You can decide who gets what, who you want to be in charge of your estate, and who will be the guardian for your minor children. Taking the time to create a will is one of the most thoughtful things you can do for your family. It provides clarity and peace of mind during an already difficult time. If you haven't done it yet, I really encourage you to look into it. Thanks so much for watching. If you found this video helpful, please give it a thumbs up and subscribe for more content on planning for your future. See you in the next one.